Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are calling file number 19180-130, Gravity Imaging versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Ian Coote, 73154 for the plaintiff.
And good morning, Your Honor. Sarah Doman, P79128 on behalf of the defendant.
All right. You told me on March 11th the settlement was close. Have we completed the settlement?
No, Your Honor. We may have taken a bit of a step back. We thought we had an agreement on a $6,000 figure. However, I think that there was Ms. Doman says that in reviewing her emails, she didn't have the authority for the $6,000. So now the parties are at $5,000 for the city of Detroit and $5,750 or $5,750 on plaintiff's side.
Well, you told me I got information that was less than accurate from the lawyers on my docket. That's not a good thing. This is what we're going to do. You're not going to settle the case? So be it. I'm not going to spend time with you today. You're that close, you either resolve the matter or we'll see you again. Your next day with me, since your discovery is closed and all of that stuff done, you just come back and we'll try it again on May the 20th? Let's see. Can't read my own writing. Yep, May 20th. Does that day work for everybody?
That works for me, Your Honor.
Yes, Your Honor. I have a 9:30 pretrial, but I'm free after that.
All right, May 20th it is. And we'll see whether or not you'll be able to resolve your file. Thank
All
you.
right. That's at 10 a.m., Your Honor.
At 10 a.m., yes, sir.
All right. Thank you, Your
Okay.
Honor.
Thank you, Your Honor.
Have a good day.
You too.
Got it. All right, who is Edie's phone?
Edie Schwartz, hi, I'm with Detroit Residential Opportunity Fund.
What case are you here on?
Natalie Dooley.
Oh, really? What's your case number?
Let's see, 19-182-537.
I don't have that case, ma'am.
Okay, this is the paperwork the attorney sent me. Okay,
Give me the case number again.
it's 19-182-537.
182.
Yep, 537.
537. The only 19 case that I have, hang on, I got a call coming about this.
No problem.
Hello? Robbins, thank you. Bye. You're in the wrong chat room. This is Judge Robbins' son's court. You want to be in Judge Robbins.
Okay,
Have a-
okay. I'll have to email him. He sent me the wrong paperwork. Okay. Thank you.
Have a good day.
You-
Ms. Tomer,
Good morning, Your Honor.
what file are you here on?
I am here appearing on behalf of Plaintiff Gravity Imaging for our pretrial conference.
Are you on case 789? Last three digits?
Yes, for the underlying plaintiff is Sarah Scott.
Well, the case is listed on my docket by the name of the plaintiff. But we already did one gravity imaging, so you're doing another, okay? Apparently
Okay.
for another one. Can you tell me who the city attorney is on your file?
Yeah, she has coverage today. Let me get you the person who should be covering her, because she is out. Margaret Lemke, I'm sorry, give me, Maureen Hillman should be on.
Maureen Hillman, I see her here.
Okay, great.
All right. Do I have both sides on 21148-789, gravity imaging versus Falls Lake
Yes, Your Honor.
appearances?
Yes. Maureen, excuse me, Maureen Heilman on behalf of Falls Lake,
Ball number.
77629.
Your appearance, Ms. Thomas?
Sandra Toma on behalf of Gravity Imaging, 84575.
All right. This appears to be our first pretrial. Has our 2.302 disclosure been made?
Yes, Your Honor.
Yes.
Both sides? Okay, then where are we on settlement, y'all? You know what we're asking about? It's a PIP case. It's a district court PIP case. Let's go. Where are we going?
Okay, Your Honor, we are just awaiting the defendants to take the underlying plaintiff's deposition. An early resolution was discussed as long as we can get that taken care of, and that's happening sometime in June. Correct me if I'm wrong, Maureen.
No, I believe it'll be June, or early July at the latest. As soon as that deposition is taken, we've got a PIP case and other provider cases that, we want to resolve after the deposition. So I would ask the court's indulgence to allow us the time to do that.
What's today's date?
It is 4/29/21.
And you want to take a deposition when in July?
No,
90 days from July?
June. I say July because we haven't been able to secure the date as yet on the PIP case. So, it looks like it's going to be June.
Well, I got a problem with that. The object of the exercise of giving you disclosures is for you to have the information necessary to resolve the file. And if you
Your
need
Honor,
a deposition, then let's get
I
that deposition scheduled in the next 30 days.
I understand, Your Honor. The problem is that we are not sure that there is appropriate coverage. That's why we need to clear the coverage by taking the deposition. And then we can settle all of the cases. There are a few questions that only the plaintiff can answer about procurement of the policy. We have been working on setting that date, but the PIP case was only recently filed and we're, trying to get the date secured. We were told by the plaintiff attorney on that case that they would give us dates in June.
This is already a month old. And what I hear you saying is you have no dates for deposition that you need to do anything on, be able to move the file one way or the other. Why can't you take the deposition in this case?
Well, we'd have the same issue. We still have to get dates from, the deponent. I would have to subpoena him separately. I don't
You're gonna have
know.
to do that anyway. He's not a party to this litigation. Is he a
No,
party
I
to
understand.
litigation?
I understand, but, the plaintiff attorney for him on the PIP case is going to produce him. Then we will cross notice on the other cases. We'll take the deposition in all the cases. We'll also file a deposition notice in this case. I just cannot get my adjuster to come up with money. We've been talking about it, they're willing to resolve, but they need to have that deposition in the can.
I understand you need other information. My problem is, why are we waiting to get it done? I understand your position.
I can work on it on the other side. I mean, it's actually the end of April, beginning of May right now. So if you would give us 60 days, we could get this all wrapped up.
I'm going to see you people again on May 20th. Does that day work for both of you?
I'll make it work.
What about you, Ms. Toma?
Yes, Your Honor, we'll make it work too.
May 20th at 10 o'clock.
Thank you, Your Honor.
Thank you.
Notice. Thank you for coming in. Wasted everybody. Ms. Porter, good morning.
Good morning, Your Honor.
What brings you here today?
I am here on a case called Gilead, traumatic brain injury versus the city of Detroit. It's case number 21, 150, 152, 810.
Ms. Bradley is your opponent?
No, I just spoke to him on the phone. Let me look at my opponent's name. It's a little difficult.
He's listed on my docket as Bradley.
Let's see. Let me see what his name is. Sorry.
You sure it's not Bradley?
No, Yvonne Bradley's, for the city of Detroit also.
Yeah, but she's listed here as representing the city. Let me check in. Let's get her in here, see if she's the one.
Sure, that sounds good.
Might make more sense here. Good morning, Ms. Bradley. You're muted. Oh, good morning.
Good morning, Your Honor.
Are you here on Gilead traumatic brain versus City of Detroit?
No, Your Honor, but I could jump in if need be.
I'm here.
What file are you here on?
Okay.
Yeah.
Okay, I got Pat Porter here.
Okay.
Yes.
And I have you listed, Ms. Bradley, as the attorney for the city.
Was there a sub of attorney filed, Pat?
I believe there was, and then a transfer from the 31st district to the 36th district. I should be on the list for who represents the city of Detroit on this case. And the plaintiff, I don't see him. His name is?
Andropoulos?
Yes, correct.
Not here as of yet, apparently.
Correct. And I did talk to him. He knows there's a hearing.
So let's send you back to the waiting room.
Okay.
Ms. Bradley, why are you here?
I am here on Dwayne Miles.
Let me ask you.
Good morning, Judge. I'm here on Dwayne Miles.
Dwayne Miles?
Yes, sir.
261.
Correct.
Who's your opponent on that file?
Matthew Ross, sir.
Matthew Ross, I think, is here.
Correct. I did see him.
All right, let's get him in here. All right, we are calling 21148-261. Dwayne Miles versus City of Detroit. We are here for what appears to be our second pretrial, your respective appearances.
Good morning, Your Honor. Matthew Ross on behalf of the plaintiff, P78174.
Good morning, Your Honor. Yvonne Bradley on behalf of the City of Detroit, P54885.
Okay, where are we on this file, people?
Your Honor, one of the issues remaining in this is that the unfortunate City of Detroit EMS was delayed in getting a bill to us, which we finally found out was in collections, which we've now requested the bill from Harris and Harris. I've since sent the remainder of the claim over to opposing counsel as of yesterday, but I still have to provide that last bill to opposing counsel. Our intention, Your Honor, is to have this matter resolved as soon as possible.
Ms. Bradley?
That's correct, Your Honor. The attorney that's actually handling the case is Laura Nemi. She actually just went out on a leave, but it is my understanding they were in negotiations to try to resolve this case.
So let's give you another date. Let's get our bills exchanged and get the file moving.
Yes, sir.
Absolutely.
May 20 work for both of you?
I will make it work, Your Honor.
We will make it work.
Calendar day.
Thank
I'm
you, Your
sorry.
Honor.
It works?
May the 20th.
It's a Thursday.
Works. Perfect. Same time, Your Honor?
May 20th at 10 o'clock.
Thank you,
Perfect.
Judge.
Thank you, Your Honor.
All right, what I'll do is I'll send out an order and let's get this thing done.
Absolutely.
Thank you for coming in.
Have a great
Thank
day.
you, Your Honor.
Have a great
Be
day.
safe.
Okay, now, what do I have here. At Porter, Alfred Ashley. Hello? Hello? Hello?
Hello?
Let's see if we've got a pair for anybody here.
Hello?
Anybody here on Prism Lab versus City of Detroit?
Yes, Your Honor.
Yes, Your Honor.
Both sides are here on that?
Correct.
Then everybody's back, else is back to my waiting room. I don't know who this is, phone number, but they're going to the waiting room too. Let's call case number 21140-785, Prism Lab versus City of Detroit, your respective appearances.
Good morning, Your Honor. This is Jeremy Noland appearing on behalf of Prison Labs, standing in for Cliff Neubauer.
You remember the State Bar of Michigan?
Yes, I am.
You have a bar number?
Yes, it's P75970.
Counsel?
Good morning, Your Honor. Alfred Ashew on behalf of defendant, City of Detroit, P82536.
All right, this is our first pretrial. Have you guys made the 2.302A disclosures?
Prison Labs has, Your Honor.
Mr. Ashew?
Not yet. We're going to make those disclosures later today. I think we have another day to do it.
Sir, they will do 25 days from March 21st. Today being April 29th, more than 21 days have elapsed.
The order I have, I think it was received April 9th. It said 21 days from the date of that order.
Right, and what's the order date? Upper right-hand corner.
You are correct. The order date itself is March 25th.
So your disclosures are overdue. What is this case about, gentlemen?
It's a standard PIP case, Your Honor.
What are we arguing about?
So, Your Honor, Prison Labs provided services arising out of accidental bodily injury. And we did some toxicology labs that we have not received payment for. So our position is the City of Detroit owes us money.
I understand that's why we're here. What I'm asking you is, what is your claim about? Do you have one series of tests? Do you have ongoing tests? Or a single test? What's your claim about, counsel?
It was just a single test, I believe. Amounting to, well, there might have been several invoices. It amounted to $4,788 in total tests.
All right.
And it's not continuing, I don't believe.
Okay, so we're basically done. And what we're arguing about is how much.
Correct.
All right, so what I'm going to do is I'm going to give you guys a return date, May 20th. Does that work for both of you?
Let me check my calendar, sir.
Yes, May 20th is fine for me.
Well, I can make it work, Your Honor.
May 20th at 10 o'clock.
10 a.m. you said, Your Honor?
I'm sorry. It'll be May 20th at 10 o'clock. It'll be another Zoom hearing. And in the meantime, Mr. Ashew, let's make those disclosures.
Yes,
We're
Your Honor.
overdue on them now. If we get back together and they're not done, I will default you.
Yes, Your Honor.
Okay, I'm not a disc jockey. I'm not making requests. I'm giving orders. And you're in violation of the court's order, sir. May 20th at 10 o'clock. Let's get our work done, gentlemen. Anything else we can accomplish today?
Nothing else, Your Honor. Thank you for your time.
All right. Thank you, gentlemen. Have a
Thank
nice
you.
day.
You too.
All right. Hello? Mr. Sparks, what file are you on today?
I am here for LVNV versus Barnes.
LVNV versus Bond.
Camilla, yep.
Okay, let me see if I got somebody here on that. All right, good morning.
Morning.
Good morning.
Who is here on LVNV funding versus Camilla Barnes?
Camilla Barnes is here.
Mr. Sparks, you're here on that file?
Yes, I am, Your Honor.
Yes.
I have prepared. You two stay. Everybody else is going back to my waiting room.
Thank you, Your Honor.
All right, let's call your file. This is file number 2114391, LVNV funding versus Camilla Barnes. This appears to be our initial pretrial, your respective appearances.
Good morning, Your Honor. Keith Sparks here on behalf of LVNV Funding P77485.
And what is your name, ma'am?
Camilla Barnes.
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes.
Where are we on this file, people?
Your Honor, we did not receive a copy of the answer, so I don't really know Ms. Barnes's position.
Tell them what your position is, Ms. Barnes.
Well, the account is not mine. I filed a written notice with the court letting them know that. I wanted to prove that I had just found out about it when I was served.
Okay, so you're claiming it was like identity theft or something like that?
Yes.
Okay. Your Honor, we would request an adjournment and I will send an affidavit of fraud along with the statements to Ms. Barnes. Can you just confirm your address for me, please, so we make sure we mail it to the right place?
It is 11635 Penrod, Penrod, Detroit, Michigan 48228.
Thank you. Yeah, we'll send you an affidavit of fraud, review it. If it's not your card, please fill it out and return it to us for review with our client. Otherwise, if you remember the purchases of the card, please contact us. We'll try to reach a resolution.
All right.
And you said, I'm sorry, I didn't understand. He said, if it's not your card, I don't have a card. That's what I don't know what you're talking about.
He's going to send you an affidavit of fraud. If you dispute the bill, saying fraud is not, the card is not yours, send it back. Fill it out and return it.
Okay.
If you record, remember that it is yours, then contact them. They can talk about resolution. This is what I'm going to do in the meantime. I am going to open written discovery in this matter, and I'm going to give you folks a return date with me. That return date will be May 20th at 10 o'clock. Does that work for everybody?
Yes.
How about you?
Yes, Your Honor. Yes, Your Honor.
May 20th, 2021. At 10 a.m., we'll have our next pretrial. Your written discovery is now open. Is there anything else we can accomplish today?
No.
No, Your Honor.
All
I'll
right.
make sure to get that in the mail today.
Okay, and I'll send this order out to you guys as well. Thank you both for coming in. You're free to go now.
Thank you, Your Honor.
Thank you.
Thank you, Ms. Barnes.
Thank you.
Okay, we are on the record. We are calling case number 21152-810.
Good morning, Your Honor. David Ash on behalf of the plaintiffs, P number 76372.
So you have both Gilead and Sears
Yes, Your Honor.
and Ms. Porter?
Good morning, Patricia Porter, P 66989 on behalf of the city of Detroit.
Okay, my first question is whether or not you people have made the 2.3028 disclosures as a court order.
Yeah, there's been we have not, I have not, and I don't believe the plaintiff has, and here's the reason. We are talking about a voluntary dismissal, and I don't know yet if the plaintiff has agreed, but the underlying claimant is a woman named Romelda Norman, and she filed a separate action in the Wayne County Circuit Court, which was just dismissed on the city's motion for summary disposition by Judge Giovan because there was no proof of any injury. There was actually proof that no injury occurred. So it's been dismissed, and we've been talking about whether this case is going to be dismissed.
Counsel?
Yes, Your Honor. I am planning on speaking to my client. I apologize. I know that we were working on the initial disclosures. I was out for COVID for the last couple of weeks. I got back this week.
How you feeling?
I'm feeling good. It was actually my second time getting it, oddly enough. Yeah, I had it back.
Born under bad sign, man. That's horrible. Glad you're feeling better. So
Thank you.
Let me make sure I understand this. There has been a finding by a court of higher jurisdiction than mine that the underlying injured party sustained no injury in the accident at issue.
Correct.
Is that what I hear you saying?
That is what the order says. Correct.
Isn't that pretty much race judicata for me?
I think so. I don't want to have to file a motion. That's why I was asking for a stipulated dismissal.
Okay, let's do this. He's going to need some time to talk to his client.
Yes.
But I've got to tell you, Mr. If things are as I understand them to be, and there has been a request made on the record for you to dismiss the matter, and you decline to do so, and if she has to proceed to a motion, I will assess costs and attorney fees.
Certainly, Your Honor. And the reason why I have to discuss it a little bit more in detail is I believe that the ruling was as to the one to Romelda, but not Marquis. I just have to go and discuss this in detail to my client, and
we'll give you some time. But I want you to know that if we get to the point where I'm asked to adjudicate something that Judge Giovan has already decided, it's hard for me to understand how that position could be continued. Maybe initially filed in good faith, but I don't understand how it could be continued after that order of a higher court. I mean, that's pretty clear to me. So let's give you a return date, May 20th. Does that work for both of you?
May 20th.
Yes, Your Honor.
My calendar. Hold on one second, please.
And Your Honor,
if
we get this resolved, we won't have to appear.
Yeah, you can just send in a stipulated order dismissal. Sure.
Thank you.
Yes, that works for me. Thank you.
Okay. May 20th at 10 o'clock will be our next pretrial. Like today, it'll be on Zoom.
Okay.
And we'll hopefully have the matter resolved given the Wayne County Circuit Court ruling. We'll send out an order today. Thank you both for coming in. We're off.
Thank you.
Thank
you, Your Honor. Have a good day.
Okay. And glad to see you doing better, sir.
Thank you very much.
2 minutes.
Morning, Your Honor.
Hi. Why are you here today, Mr. Truba?
I'm sorry, did you ask why I was here?
Yeah.
LVMB and Smith, 594.
Okay.
Judge, we've actually resolved this. We submitted to the court a stipulated order on April 15th. Just check the ROA. It doesn't look like it's been checked in yet.
There's no way in the world it's going to catch up. We don't have our people on the second floor are working two days a week.
Okay.
What did the stipulated order do?
Well, it was kind of a universal settlement. We didn't put everything in there, but the nuts and bolts of the order that's going to be down at the court is we're going to agree to set aside that renewed judgment, which would result in the case being dismissed.
Okay, so I'll just wait then for that to catch up with the file. You filed that on the 15th?
Yeah, yeah.
By mail?
Yes, we did. So I know.
Yeah.
The hope was in 2 weeks it would have caught up with the file, but it didn't.
It ain't happened. What I'll do is I have them call downstairs and see if that's come in. Hang on for a second, okay?
Okay.
All right, Mr. Truba, what I'm going to do is I'm going to just cut you loose.
Okay.
And assume that sometime in my lifetime, this will come
All right.
up. I'll set the file out for review in about 3 weeks. And if I don't have that order by then, we'll set it for another date.
Okay, that's good, Your Honor. Thank you.
All right, have a good day.
You too.
Bye-bye. All right, Ms. Nonis, you don't seem to have an opponent, so you're off to the waiting room.
Okay.
I believe Mr. Buchanan's opponent is here. Where I just saw him. Where was he? Here we go. Okay, I seem to have both of you guys on 2016275 Corrigan Towing versus Lock Automotive, your respective appearances.
Good morning, Your Honor. Guy Conti on behalf of Corrigan Towing.
Good morning, Your Honors and staff. Brandon Buchanan on behalf of Lock Automotive Group.
Mr. Conti, you remember the State Bar of Michigan?
I am, Your Honor.
You have a P number?
P68889.
All right, now, Mr. Buchanan, your bar number.
P67499, Your Honor.
All right, going forward, gentlemen, somebody sent me a set of interrogatories, request for production of documents. The court doesn't get those. The only thing I get in terms of Written discovery is I get requests for admissions and answers to requests for admissions. All that other stuff does not come into my file. So where are we on our discovery, gentlemen?
Your Honor, Mr. Buchanan has issued some discovery to us, but I had a conversation with Mr. Buchanan. This is a case in excess of $20,000 because of storage charges, and Lock Automotive is a commercial entity. I suggested to Mr. Buchanan that if I could get my client to treat this as a consumer case instead of a commercial entity case, we might be able to settle somewhere closer to the $1,200 number. And I'm trying to get authority from my client for that at this point, because of course there's $1,000 storage limit on a consumer case. So I'm trying to get that authority now, Your Honor, and hopefully if I can over the next few days, I'm hoping that this case will settle. That is the status, Your Honor. We have not answered the discovery because, quite frankly, as I mentioned to Mr. Buchanan, I don't want to go through all that work if we're going to be able to settle. So we're trying very hard, and I'm trying very hard. And I've had, like message tag with my client, and I'm trying very hard to get the authority to settle at that level.
Well, here's the situation. I don't want to hear anything about settlement negotiations. If you guys are able to resolve it, that's really spiffy. If not, then we need to get moving on our discovery. Now, you know the status of the file, I don't.
Yes, Your Honor.
I certainly am not interested in hearing about settlement discussions. So what I'm going to do is I note that I opened your written discovery a couple of pretrials ago. So let's see, that was on March 25. So I'm going to give you another date, and that's going to be May 20. Does that work for both of you?
That works, Your Honor. It's possible I may work out not settlement, but I might work out a dismissal before then, and we would submit that to the court, Your Honor.
That can certainly be done.
Okay, that's fine, Your Honor. May 20th is fine.
That work for you, Mr. Buchanan?
Well, I'm just sitting here trying to, in my head, calculate the days. Because even if, again, it's speculation as to whether it's going to settle, whether it's going to be dismissed. But in the event that it isn't, I want to have enough time to go through the answers to my discovery questions in case we have to go on.
Well, here's the situation. If you don't get it done, then of course you have your remedy under the court rule to compel answers to your discovery. I mean, that's not a complicated situation. Either you guys, it's either you're gonna resolve it or you're not. If you're not, then you need to consider filing your motion to compel your answer to your interrogatory request for production document. But we don't want to just have the file drift. That's the whole point here. So I'm going to give you guys that May 20th date at 11 o'clock. It'll be on Zoom again. And Mr. Buchanan, you have the remedies available to you under the court rule. You guys would it help you to go to the chat room, or you need to have communication with your clients?
I don't believe at this point, as Mr. Conti said, he and I already had some conversations. It's a matter of him getting with his client.
Okay, there's no point putting you in the chat room. All right, May 20th, 11 o'clock, gentlemen.
All right, thank you, Your Honor.
Mr. Buchanan, I'm going to give you a call this morning, okay?
All right.
Thanks. Thank you, Your Honor.
Thanks, Judge.
We are on the record calling for motion for summary disposition 20161-185 Jefferson Capital System versus Patricia Dockery. Your respective appearances.
Good morning, Your Honor. Attorney Ashley, known as P77029 on behalf of plaintiff.
Your name, ma'am.
Good morning, Your Honor. Patricia Dockery, improper.
Your motion, Ms. Norris.
Thank you, Your Honor. So we filed our motion for summary disposition under MCR 2.116C9, no valid legal defense, as well as 2.116C10, no genuine issue of material fact. So if you read through our brief, Your Honor, the defendant first contested that it was fraud. Then she said someone was living there. Then she said it was a squatter. Then she said she made payments. Then she said she took it to DTE for a third party to pay it off, which it wasn't. If you look at her discovery responses that we sent, they're very contradictory and very evasive, as if to purposely avoid liability. She admits to the account. She admits to not making payments in full. But then she admits to getting the bills. Then she claims that there was a squatter there. We also supplemented our Exhibit A, which is a complete, well, I don't think it's a complete account history, but there's over 200 statements on the account that show the service address, which was her current address, that payments were consistently made until they weren't, that the bills were sent to her. As I stated, she admitted that she didn't make all the payments. I mean, I really don't see how she has any valid legal defense that she claims this account was fraudulent or that there was a squatter there. If there was a squatter there, they sure weren't going to make payments. So I think her argument fails. And then as for no genuine issue for prong C10, again, if you present this before a jury, there's no factual finding other than on behalf of plaintiff that she opened the account, whether for herself or a beneficiary of someone who lived there. Payments were made on the account. She defaulted on payments. She's responsible for the balance owed, and the balance is correctly stated. So we would ask that our motion for summary disposition be granted based on everything we've provided in our brief, as well as her responses to discovery, which clearly admit to the account and not paying it in full.
Ms. Dockery.
Your Honor, I completely deny these allegations. I put in my answer and my response that this bill that they have presented was not my bill. I told this woman that I did go to DTE when I found out the house had been vacant during the time that this bill was created. I did not live at this property at the time that this bill was created. Didn't know about it. When I moved back in this property in 2015, I found out that there was this bill that I didn't know about that somebody had come in and created. So if you look at Exhibit A, when I went to DTE, they were located on Gratiot Avenue. And so they had to flag this fake account. And so in order to flag it, they put the name on the account, Patricia Dockery doubled, so that would flag that this was a duplicate account and it was not me. If you look at Exhibit B, that is my accurate account and my accurate name with DTE Energy. And I told these people that was not my bill. So what happened when I went in and DTE flagged this fake account that somebody had opened in my name, they were at that time located next door to St. Vincent de Paul. And they said, we're going to help get rid of this bill. If you put $150 down, St. Vincent de Paul will clear this thing out and make this fake bill go away. So I did what they asked me to do. And this never appeared ever again for 4 years until now, till this woman comes up 4 years later and says, oh, this is your old bill. I thought this thing was completely resolved. It's not my bill. I have an accurate statement of what is my bill. And this woman refused to listen. So, Your Honor, my argument is I have a valid defense. I want a trial, probably a jury trial, because I have an accurate defense against this. This is not a bill that I owe, and they can't prove it's a bill that I owe.
Ms. Notice.
Your Honor, we have proved it's a bill that she owes based on all the account statements. Further, whether she was living in the property or not, there was an account in her name for the property address that was accruing services that she is responsible for. She has provided no proof, no police report there was a squatter, nothing. And like I said, her answers are contradictory. 1 minute it's a squatter, and her answers to discovery, it is if she knows who was there and they were supposed to pay and then weren't. She admits to not paying. And then realistically, logically, if she were to go into DTE and contest this account, they would close it as fraud. They're not going to tell her that a third party is going to pay it off and then have her make a payment. So her actions in alone contradict her alleged legal defense that she's claiming it's not her account. And like I stated, she's been making payments throughout the history of the account. I mean, if this was a fraudulent account that she claims the property was vacant and there was a squatter, there wouldn't be any payments. I mean, there's payments back in November of 2007. There's payments up to date of, going through all the accounts, 2011.
Okay.
I mean, there's over 200 statements that prove that this is a legitimate account. Payments were made. They were for the property address, addressed to the defendant at the address. As I stated in her discovery request, she admits to the account. She admits to receiving statements. She admits that she didn't make all the payments. But then when it comes to the liability, she's trying to deny the liability and say that a third party was going to pay it off. Well, what is it? If it's fraud, nobody should pay it off. If it's not fraud, you probably tried to get legal assistance, or, well, not legal assistance, but the third party assistance to help you pay it off. I mean, DTE is not going to say, you can test your account as fraud. Let's go see if someone else is going to pay it for you. Logically, that makes no sense. So as we stated, Your Honor, in our brief, based on her discovery responses, the circumstances of this case, and everything that's been presented, she does not have a valid legal defense, and there's no genuine issue of fact, and a motion for summary disposition should be granted.
All right, the court is prepared to rule. My ruling will be based on MCR 2.116C10, since both of you provided information outside of the pleadings. The first thing I note in the defendant's answer to a motion for summary disposition is unsupported by affidavit. Furthermore, the defendant's explanation as to Exhibit A having a name repeated twice to be demonstrate that this is a fraudulent account, and Exhibit B being her name to demonstrate that that's the correct account. There's no support in the record for that. This is her explanation of what happened, or his hearsay, and there's no affidavit from anyone saying, I'm with DTE and we generated this account with two names on it to show it was a fraudulent account. In her answers to interrogatories, defendant acknowledged having its electrical service at the Belmont Street address, acknowledged making payments on the account. Further, even in her answer to summary disposition, she said she made a payment on the account. So looking at the totality of the pleadings, the affidavit and the billing subpoenaed on behalf of the plaintiff in this matter, the unsworn answer to motions filed by the defendant in this matter, I think that we need to look at MCR 2.116 G4. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavit or as otherwise provided in this rule, set forth specific facts showing there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. It is the ruling of the court that there is no genuine issue of material fact here. The motion for summary disposition filed on behalf of plaintiff in this file will therefore be granted. Ms. Docker, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. I have the order for summary disposition proposed that was sent along with the motion. The court will enter that at this time and we'll send out copies to you both. Thank you both for coming in. We are off the record.
Your Honor, I have one question.
Ma'am?
I do plan to file an appeal. I want to get a transcript of this hearing, and I need to know the process for getting the transcript.
Ma'am, you would contact the court reporter's office here at the 36th District Court.
Court reporter's office?
Yes, ma'am, to get your transcript.
All right, I will be appealing. Thank you, Judge.
You have an absolute
Have a great day.
Thank you. We're off the record.